Good evening, viewers. Welcome to another episode of Insights and Analysis with yours truly, Joel Bhagwandin. On today's episode, I wish to make it very brief and where I want to provide some brief commentary today on about three or four issues that are dominating the political discourse right now. The first that caught my attention is the US ambassador at the sidelines of an event recently was asked about the sanctions, the OFAC sanctions, and she was asked apparently to comment on that and whether the US had anything to do with the decisions by the commercial banks, by the financial institutions. And her response was that the banks acted independently, that nobody consulted with them. And that response that she provided, the apologists and the trolls on behalf of the sanctions subject have been trying their best to spin that narrative or to create a narrative that something is woefully wrong, implying that for some reason the banks ought to have consulted with the US Embassy or the ambassador of the United States government. So they're trying to create or to generate, using the ambassador's response, to generate a narrative that is convenient or reflective of their position as regards the OFAC sanctions and the implications thereof. In a very disingenuous manner, of course. Now, I saw this is the second time they've done this with a statement put out by the US ambassador. There was another statement when asked a question by the media again. They were trying to get the US ambassador to say whether there is a relationship or a connection between the sanctioned individual and visa revocation of persons, whether there is any relationships there or connections. And she said very diplomatically that visa revocation and the OFAC sanction, those sanctions are two different matter administered by two different US government agencies. She did not answer the question directly that they were trying to get her to answer. They nonetheless took what she says and tried to create a narrative convenient to them for that. Now, the thing is that when we cut through all the narrative and cut through all the noise that they're trying to create or propagandize, you got to realize that the ambassador is a diplomat. She's a career diplomat, and she would never give a direct response to certain matters. She would never give a direct response to certain matters. Her response, any career diplomat, and especially on sensitive issues, sensitive matters, and especially on issues that relates to national security, that has national security implications, no career diplomat would ever give you a direct answer. They will always be diplomatic. However you want to interpret that, that is up to you. The danger, however, with this group of apologists on behalf of the sanctioned subjects is that they're creating a dangerously false narrative to suit their agenda, and we must not fall victim to that. So that is what I want to that is an important point that I want to point out in relation to the ambassador's statement when asked certain questions by the media. And how do you interpret or read between the line? And you have to read between the line when a diplomat speaks. No diplomat will give you a direct response. Now, let's dissect further. Let's dissect further her recent response in relation to the OFAC sanction and the actions of the banks, the commercial banks. The apologists are suggesting that the commercial banks had no authority to act in the manner they did in relation to those sanctions, in relation to those persons who offer themselves to be candidates on an OFAC sanctioned political contender, political parties list. They're using the ambassador's response to suggest that the commercial banks, the financial institutions, had no such authority or basis, rather, to do so. But what they did not point out is that the ambassador said what she stated, her response was grounded in facts. The media went and twist and turn her response from a previous interview, but what she said, whatever she said was grounded in facts. She stated facts. What she also said on this occasion that they conveniently ignored is that everything in relation to the OFAC sanction is there on their website. Everything in relation to that is there on their website. And this is the part that they omit, which I'm going to read for you verbatim from the OFAC website. Now, they want the US ambassador to comment. Let me get this clearly. Let me put this over clearly. A certain section of the media, or maybe not the media, maybe the media just simply doing their jobs to get the ambassador to comment on these politically sensitive issues. But the apologists and the persons associated with that sanctioned party and individual, they want the US ambassador to say, or they would like the US ambassador to say, that the actions of the financial institutions to terminate those accounts had nothing to do with OFAC sanctions. But what she said is that everything in relation to OFAC sanctions and the implications, it's there on their website. And this is what the OFAC statement reads. And I'm just reading one paragraph as it relates to the financial institutions action. There's a subheading there that spells out the implication of sanctions. And this is what it says. In addition, financial institutions and other persons that engage in certain transactions or activities with the sanctioned entities and individuals may expose themselves to sanctions or be subject to an enforcement action. Let me read that again. In addition, the financial institutions and other persons that engage in certain transactions or activities with the sanctioned entities and individuals may expose themselves to sanctions or be subject to an enforcement action. The prohibitions include the making of any contribution or provision of funds, goods or services by, to, or for the benefit of any designated person, or the receipt of any contribution or provision of funds, goods or services from any such person. Now, the ambassador didn't read all of this. She didn't cite this. She made no mention of this. What she simply said, everything is on the website. She directed the media and the public go to the website to read what the OFAC sanction says. These clever apologists, however, to suit their narrative, they would take anything that the ambassador says to spin it and to create a narrative that suits their agenda. So don't be misguided or misled by their propagandization of and interpretation of what their own interpretation of what the diplomat says, which is completely divorced from the facts, completely divorced from the facts, completely divorced from the reality. The second issue that I want to comment on today's episode is one of the now dissolved political party that was consumed entirely by the sanctioned political party. That political party which was formed to contest the 2020 election, that had some degree of credibility, drawing from the credibility, the established credibility and reputation of the persons who founded that party. The persons who founded that party, I'm referring to here ANUG. There was a political party called ANUG. Was founded by some distinguished Guyanese professionals. And so I would regard that political party, by virtue of the credibility and the reputation and the character of the founding members, I would view that political party as a party that once had some degree of credibility. The party's leadership changed. The founding members became inactive before the leadership changed, but they remain members nonetheless. The new leadership of the party took the party in a completely different direction, a completely different path, and I dare say a dangerous path in relation to Guyanese politics and the dangers of what could potentially happen if they have their way to the country, which would impact all of us negatively. That party now is, as it stands, according to me, it's dissolved, because when they signed on the so-called collaboration, they call it a collaboration, not to label it a coalition, which was nonsensical in itself. The idea to say that this is not a coalition, it's a collaboration, they're playing the creativity in your choice of words doesn't change what it is. If I have a glass of water here, I could say it's milk, I could say it's blue, I could say it's black. I could say whatever I want about the water, but it will remain a glass of water. So whether they want to call it a collaboration, a coalition, or whatever other adjective they choose to use to deflect from what it actually is, it will not change what it is. And in fact, it is even worse, because a coalition, if you look at the model that was first introduced in Guyana with the APNU AFC, a coalition is where two separate entities come together, form a singular unit, form a singular unit as a joint venture. Think of it in a business sense as a joint venture. And in that joint venture or that coalition model, they do not lose their respective identities. They maintain their identities. In the case of the AFC, we can argue that their philosophical or ideological identity were lost based on when they first launched or what they became in 2015. That's a different matter that we can deal with. But the AFC maintained at least for an optical illusion, they maintain their identity, their physical identity in terms of their brand, in terms of all their other promotional materials, their theme, their color code, everything they maintain. We can argue that they lost their ideological identity, but their physical identity they kept. Right? They were a distinct party from APNU. So a coalition ideally is whereby it's similar to a joint venture in the business sense, in the corporate world, whereby two entities come together to pursue common goals, to form synergies towards achieving a common goal together as a singular unit, but they remain separate entities. They remain separate legal entities, that is. Their branding remains separate and distinct. Everything else they maintain. They don't merge and become one. So here you have, now that I'm talking about it and thinking about it, which I didn't intend to, is that you have this political party that they said was signing a collaboration agreement, went beyond collaboration, went beyond even a coalition. They have now been consumed and they've become part of this singular political entity. So they no longer have their separate identity and separate mission and separate constitution. That party is now dissolved because they're not appearing on the ballot box. They did not submit a separate list, and there nowhere on the ballot box will you have ANUG's party symbol or the voting for ANUG. It's one party. So it's actually turned out to be worse than a collaboration, which is another, which when you think of it now, that's another form of dishonesty. That's another element of dishonesty. Saying one thing, but in reality, you've gone beyond that. You've gone worse than the coalition. That aside, there are two outspoken members of that party that seeks to dominate this space, the public commentary space, and that seeks relevance and visibility and everything else. There are two persons. One is the party leader, well, supposedly the leader of the party, and the other who did not participate in the executive election remains, according to him, affiliated with the party and speaks indirectly on behalf of the party. So I have to identify this individual with that grouping. And so this individual I'm referring to, in one of his presentations, He visited the gas to energy project. He visited the site where the gas to energy project is being constructed to say to the general public that the government has failed this project, that we are in 2025 and the gas to shore project is nowhere to be seen. Now, that is not just dishonesty. That is something worse than dishonesty. And I say that because you got to think for a moment that this group, this individual and his colleagues, the grouping that he belonged to, or the group that he identifies with, that he defends directly and indirectly, these are people who are putting themselves up to run this country. And running a country is serious business, and it's not an easy task. There are many complex, moving parts, difficult and complex decisions that have to be made on a daily basis to run a country. So, what is the status of the gas to energy project? And what are some pertinent facts about the gas to energy project? The gas to energy project has three components. The first is the pipeline from the gas field offshore to onshore. The second is the power plant, and the third is the NGL facility. So three pieces of infrastructure. How is it structured? The pipeline infrastructure, that first element, that first piece of infrastructure, which cost about $1 billion. $1 billion, the pipeline is about $1 billion, $1 billion US. That has already been constructed, and Exxon had responsibility for that. So the pipeline is already built, it's there, the pipeline is there. So that's the $1 billion, but you can't see the pipeline because it's beneath the surface. It's not on the surface, so you won't see the pipeline. It's a pipeline infrastructure below the Atlantic Ocean that runs from the gas field in the Atlantic Ocean all the way to Wales, and it's buried. So you're not going to see that physically, but it's there. That is completed. The onshore infrastructure now, which we got, I think it's the onshore infrastructure, the total cost for the onshore infrastructure is about $700 million. So that takes the total cost for the project to 1.7, nearly $2 billion US dollars. Those facilities are also work in progress. Yes, it is true that a commitment was made in 2020 that it was the goal, it was the target to have this facility up and running by 2025. But the facility is not yet completed, and there are many unavoidable reasons for that. There has been, first you had a lot of opposition elements who mounted a protest against the project. The opposition was fought against this project. There were numerous court cases in relation to this project aimed at blocking the project. There were court cases. Hundreds of letters were written by a particular group of persons protesting, related to Nigel Hughes, by the way. A relative of Nigel Hughes, Elizabeth Dean Hughes, I believe is her name, and a group of people led by her, they've written hundreds of letters from since this project was commenced. They've written, they filed legal cases. They've written to the Exim Bank. They were trying to get Exim Bank to block the loan. They've done it all. Fortunately, it was all futile. But the fact remains, you had a group of people that were working assiduously to block this project. That aside, there were other events that led to the delays. There's an issue between with the contractor. It was a joint venture firm that was constructing this facility. They had a dispute. That dispute is being arbitrated, but it is not delaying the work. It is not delaying the work. The reality is such that these are events, conflicts, and so on, are things that are unavoidable in the real world. It is unavoidable. And so that is why you have laws, you have rules, you have regulations, you have a system in place that whenever those events arise, there's a mechanism in which to deal with them. And of course, conflicts, disagreements, disputes, they ultimately lead to delays. What is important is how you manage those disputes. And that is what is important, how you manage those disputes. Because the objective of any government or any entity in managing any project, these events, such like events, they're unavoidable, but you want to be able to, while it is unavoidable, whenever it arises, it is how you manage it. It has to be managed in a way to minimize the impact, minimize the damage, managed in a way that is amicable, that will yield at the end a mutually beneficial result to all the parties involved. And I want to give you another example. This is the situation with the gas to energy project. So it's not a field project. In simple terms, the project is a work in progress. That is it. It is a work in progress. It will be completed. The risks are going to be mitigated and minimized as practicable. Now, and these, you can't blame the government for that. You have to credit the government, in fact, not blame the government, but you got to credit the government that when these disputes arise, how they manage it, because you got to manage it, as I said, in a way that minimizes the adverse impacts that could flow. So let me give you another case example that is more relatable. the Skeldon project. The government and one particular individual from the government for decades was blamed and continued to be blamed, continued to be the one who carries the burden of the failures for that project. And again, the opposition would not tell you the truth. It's not in their best interest to debate the issue from a factual perspective or to shape their argument within what actually occurred. What are the facts? So the Skeldon project, you got to understand the history and the variables involved in that project. When, there was a company named, before Gaisuku became Gaisuku, before the state took over Gaisuku, the sugar industry, sugar production was managed by a UK firm called gov't. And gov't left, the state took over. This is during the nationalization. This is under the PNC era, the Barnumite era, when you had, his policy nationalize everything. And then they realized when they nationalized Gaisuku that we didn't have the skill, we didn't have the experience, the skills, the competence to manage it. And this was under Hoyt. Barnum had already died then. So Hoyt, he invited gov't to come back. This is in the late 80s, around when Barnum died, 85, between 85 to 89. Barnum died in 1985. Hoyt succeeded him. And Hoyt invited gov't to come back. That manifested sometime around 1988-89, when gov't did come back. They accepted Hoyt's invitation, but the form in which they came back through by way of a management contract. So, and that was brokered by Hoyt, late President Desmond Hoyt. So Hoyt brought them back by way of a management contract to manage Gaisuku. So Gaisuku remained a state-owned entity. It remained with local managers, but gov't was contracted to manage Gaisuku by way of a management contract. There was election in 1992. You had a change of government in 1992. That was when the PPPC won the 1992 elections. They maintained that arrangement with gov't. gov't remained, because the contracts were renewed, so they continued to operate under that management contract for Skeldon. For Gaisuku. Now, when we were informed that we were given notice that we would lose the concessionary market, and even before that, Gaisuku's performance was deteriorating even before that. And so there was a feasibility study that was done by gov't. So they had a management contract. Then they were engaged in a separate contract with the PPPC government this time to conduct a feasibility study that would respond to the loss of that concessionary market, and that would, in so doing, make Gaisuku financially viable and feasible within, within the context of the challenges of that era, of that time. There was a feasibility study that was done by Booker T. Coming out of that feasibility study was the recommendations to move sugar plantation towards the east because the soil is more fertile towards the east. And that is where the Skeldon project was conceptualized vis-a-vis the feasibility study that was done by Booker T. Booker T then submitted a feasibility study with the recommendations to the government at the time, which was the PPPC government. Because sugar was so important to the economy and we had to take decisive action, the government then decided to implement the recommendations of Booker T, of the feasibility study, which was the Skeldon project. In so doing, Booker T was then engaged again. Now remember, they had their management contract. So that management contract was carried out by a separate team. Then the same company, but another dedicated team, was now engaged, the same firm engaged, but different teams of personnel. One team on the management side, another team now engaged via a separate contract to execute their recommendation, which is to build the Skeldon project. So what does that entail? It entails, so they did the feasibility study. Now they're engaged in another contract to construct, to build this facility. Well, they didn't build it. Their role was to execute, to have oversight and supervision of this entire project. They were in charge of that project, Booker T. What were their roles and responsibilities? So they were responsible for setting the technical specifications of a contractor to build this facility. They managed the entire tendering process. They participated, they managed, they oversaw the evaluation. There were two, if you go back and you research this, there were two firms. There was an Indian firm and a Chinese company that bid to construct the Skeldon facility. The contract was awarded to the Chinese. At that time, there was a lot of debate, why not the Indians? Because there was an argument back then that the Chinese know nothing about sugar. The Indians are in the sugar business and they know the sugar business better than the Chinese. Nonetheless, the government was guided. The government had no other export but Booker T because they've had a history in this country managing sugar. And so it was Booker T that recommended, that selected the Chinese farm over the Indian farm. And that is what they went with. So the Chinese farm went and was awarded the contract to build the factory. All of this overseen by Booker T, vis-a-vis they're contracted by the government to do this job and to do it well and to do it professionally. They were also given the supervision contract. They now had the responsibility to supervise the project. So what happened in that supervision? Booker T eventually failed to honor their terms of the supervision contract. There were many deficiencies in that project that ultimately rests with this supervising firm, which is gov't. There were many issues. And so the government, because of those, so a lot of disputes now started. A lot of disputes arise in relation to the Skeldon project and the manner in which they managed that project, as well as the management contract they were having issues with. The government now, to remedy this, they couldn't even take them to court. The government, to remedy this, remember here the message is, gov't messed up that contract. The government, and that was the source of dispute between gov't and the government. The government could not even sue gov't. They couldn't even take them to court because in the contract that they had, that Hoyt brokered with them, any court matter or arbitration has to be done in the UK, in the United Kingdom, in their jurisdiction. So the government had to find a creative way to get them in the local court, because the current contract did not allow the government to take them to the local court. We had to go to the UK, and that was a costly and time-consuming process. So how the government got them to go to court? The government stopped paying them. So remember, they had different contracts. The Skeldon contract was a different contract, and the management, they still had the management contract for Gaisuku. So the government decided that they're going to stop honoring their payments on the management contract. That was a creative way engineered by the government to get them to go to court, because there was no breach on the management contract. The government breached their side by stopping their payments. And so they took the government to court. And guess who was their lawyer? Nigel Hughes. All this coming up from since in the 2000s, coming up all the way to 2015, you know. Nigel Hughes was their lawyer. Nigel Hughes took the government to court on behalf of gov't for the court to order the government to honor their payments that they stopped paying gov't for the management contract. Now the plan was that once gov't take them to court, the government know that they will have to pay gov't that money on the management contract. But the plan was to now use that opportunity in our local court to file a counterclaim now for Skeldon, which they did. The PPPC government did that. They filed a counterclaim to sue gov't for Skeldon in the sum of $4 billion. $4 billion. But guess what happened to that counterclaim? The court only ruled on the management matter, the forest matter, in favor of gov't. They did not rule on the government's counterclaim. And by this time, we're now in 2015. By the time the government decided to appeal that decision now, to get the appeal court now to look at the counterclaim, that was in 2015. And you know what happened in 2015? You had a change of government. Remember who was the lawyer? Nigel Hughes. You had a change of government. The APNU came in. Nigel Hughes now, he's the leader of the AFC at that time, part of the AFC. His wife became a minister. Guess what happened? The APNU AFC government withdrew. They dropped the matter. They dropped the case, withdrew the appeal from the appeal court. And guess what? gov't walk away without any liability. Without any liability. Walk away. $4 billion that we were going to sue them. Those are the facts. And I know this because I studied it. I did the research. I went to the court. All the documents, all the affidavits, all the evidence that were filed in the case, it's there. To a thick pile of document like this, I personally researched this case. Because for too long, you're hearing one particular narrative about it. So I was interested in finding out what really happened. And this is what happened. So I use this example with the gas to energy that to say that you will have disputes, contractor not honoring their contractual terms, contractor failing the project. There is provision firstly in the contract. There are mechanisms in the contract to deal with those. And beyond the contract, there is the court, you have laws, you have regulations. Beyond the local jurisdiction, you have international arbitration and that type of stuff. So issues of this nature, and especially for complex projects like these, they're unavoidable. While you want to minimize it or to mitigate it, they're unavoidable. But it is how you manage it. In the case of the gas to energy, despite the delays, the circumstances surrounding those delays, the circumstances surrounding the dispute between the contractors, and even dispute with the government as well in relation to some of the costs, the government, credit to the government, they have managed to minimize the damages, minimize the impact on the project, because while those matters are being arbitrated, they've agreed, the contractors have agreed they will continue working, the project will not be stalled for that reason while these other matters are arbitrated. And that is credit to the government, which these guys will overlook and they would not tell you. Or they would not tell you that side of the story. They don't want you to understand that side of the story. But this is the real world, and this is how it's all about management. It comes down to management and how you manage conflicts, how you manage disputes, how you manage risks, how you mitigate the risks, how you minimize the risk. Okay? So I think I've gone way beyond my 30 minutes, but I needed to tell you that Skeldon story. So thank you for listening once again. Thank you for tuning in. Until next time.